Deploy and Advocate Bastian Thienasen. I think that's the surname. I'm sorry if I'm not pronouncing his surname properly. But they were only, yes, they came on board. I don't know at what stage, but as that period, I proceeded to finalize the 63-hour and the bail appeal that followed later. But I know that they were later then involved with Advocate Santos Manilal being the DDPP and project owner of this case. When I ceased to be the prosecutor in the case, I think so was Advocate Ramsemi and Advocate Tlhatswayo. So the team led by Advocate Manilal took over the two cases, and I think they are still the prosecutors.
You say the team without, it's a new team without, new in that it now doesn't have Advocate Ramsame and Advocate Tlhatswayo.
That is correct, Commissioners.
Okay.
The team of Advocate Manilal took over the two cases, and Advocate Ramsame ceased to be the prosecutor in the Lushaba case, so did Advocate Tlhatswayo.
Okay.
I don't know at what stage they were told to no longer be part of the case, but I know for a fact they are no longer part of the two cases.
All right. Maybe just correct my assumption, or what I thought things meant. When you were setting out the 4 different streams that you have, each one of them led by a DDPP,
Yes.
I assumed that therefore there's only 4 DDPPs in IDEC. You now make a reference to Advocate Manilal.
That's correct.
As a DDPP.
Yes.
So does that mean you have more than just the 4, and where do they fit in these different streams that you have?
No. Commissioner Baloyi, at the time when the streams were set up, Advocate Manilal was still a senior state advocate. He was not yet a DDPP. And he was reporting to one of the DDPP's, Advocate Vetboy. And he only later became a DDPP. I think he went for interviews at some point for the position and was then appointed formally as a DDPP and became part of the DDPPs. And at that stage, then it would have been me and Advocate Manilal, Low, and Advocate Vetboy, even though Vetboy, her position was on contract, which ended last year in December 2025. And there was Advocate Annemari Friedman. So at some point we were 5 with the appointment of Advocate Manilal as a DDPP. We then became 5.
So when Advocate Manilal gets appointed, you say he gets promoted, he becomes a DDPP.
Yes.
When he gets appointed to replace you in these matters, DDPP Low is again overlooked. He's also again not part of it. He's not the default.
He's like, yeah, that is correct, even though the case falls
under his team, his stream.
Under his stream.
Okay. Thank you.
Thank you. On about 14 October 2025, I'm reading from paragraph 41, when the matter was due to proceed, the magistrate recused himself on the basis that he had been subpoenaed by the commission. I was of the view that the reason given was not legally sound, and after consulting the team and the investigating director, it's supposed to mean we, because I was not doing it for myself but for the team, I launched an application to review the recusal. We consulted with the ID, we informed her about the recusal, and that the magistrate, the reasons that he gave were not in line with the established principle of recusal with reference to the decided cases, and therefore the unit then decided we shouldn't leave it lying. I must say, Commissioners, that it came as a surprise to both me and Advocate Mshololo, who were defending on the day, that before we started, the magistrate just said, I want to address the two of you have been subpoenaed by the commission, and as a result, he was recusing himself. He did not give us an opportunity to address him on what he was anticipating to do, and that's one of the reasons why we then took up his decision on review to say, in line with decided cases, at least you ought to have had us engage us, but in any event, the reasons that he was giving were falling short of the established principles, and that is why we took the matter up on review.
Opportunity to address him when he decided to recuse himself. Why was that not your consideration on the bail issue? Because in the bail issue, he didn't give the accused. We later learned in the appeal that the accused were not given the opportunity to address him on that condition.
Yes.
I'm not probing at this stage, it's because you've touched on it, but it is a subject of interest that I would like to hear you on, not necessarily now in full.
Yes.
But it's something that I would like to engage you on.
I understand that. Can I quickly just take out a copy of my book here just to make... yeah. Commissioner Baloyi, when the reason for that was, and we looked at the provisions of Section 60 of the Criminal Procedure Act. Especially at 60, subsection 12, if I'm not mistaken, I want to go there. Section 60, subsection 12, the court may make the release of an accused on bail subject to conditions which, in the court's opinion, are in the interest of justice. And Section 60 says the magistrate must weigh up the facts presented before him and the evidence before him. And at the time, even though neither of the parties had addressed him on this specific issue or condition, but our understanding was that he has the powers in terms of Section 60, subsection 12, to impose any conditions which, in his opinion, were in the interest of justice, allowing him to release the accused on bail. We objected to the appeal on those grounds, but when one reads the record of the matter at the High Court on appeal, and the presiding judge took me on that, and I had to concede, commissioners, that yes, much as I didn't know much about the case on the day of the bail application, I was seated there, but I remember that my fellow prosecutor, Advocate Tlhatshwayo, was not engaged by the magistrate, neither were the defense, before the magistrate decided on this condition. And for that, that's the first point. But secondly, the magistrate did not give reasons for imposing this condition. And I think those two factors are what swayed the decision in favor of the defense. The High Court saying, when reasons are not given, it's difficult for a party to the proceedings to know why a decision was made against them, and there's a constitutional case to that effect. And furthermore, the fact that you are not engaged to address the court on that was also wrong, and that led to the conditions being set aside. On hindsight, yes, we ought not to have opposed it on those bases, but at the time you're looking at the act, it says there's nothing wrong that the magistrate did. He has the powers in terms of 60-12 to impose any conditions. Had he given reasons, had he engaged us to address him, that condition would have stood.
Okay. We'll come back to it, Mr. Serunye, and because Ms. Johnson did testify to this, specific questions were asked of her about this, and she had certain answers and explanations. So I would like to hear your views about it, but we'll get to it.
Thanks, Commissioner.
Thanks, Ms. Paul.
Thank you. Right.
Thank you.
Paragraph 42, the accused thereafter abandoned the Section 63 application. That is now, after the magistrate had recused himself, the chief magistrate was trying to arrange another magistrate to take over the 63 application. And the accused then, because of that delay, they then brought a Section 65 bail appeal. Section 65 of the Criminal Procedure Act bail appeal. We again had a discussed with our boss, and we're given a go-ahead to oppose the application. And both matters served before the High Court, and the judgments are attached as PS8. The judgment for the bail appeal and the order for the recusal is PS9. In the bail appeal, PS8, the High Court agreed that the presiding magistrate's decision to impose the decision without engaging the parties and giving reasons was wrong in law and therefore ought to be set aside. On PS9, in relation to the recusal of the magistrate, the High Court ordered in our favor to say, yes, the magistrate ought not to have recused himself for those reasons given, not engaging you, and the reason given is also not in line with your rugby union matter. The bail appeal succeeded.
Serunye, just before you proceed with the next paragraph, in practical terms, you would have had a conversation about the bail amendment application, the 63. Did you have a similar consultation with the ID regarding now the bail appeal, and did she give positive permission or consent for you to proceed with appealing? I mean, opposing the appeal.
We did, commissioners, and we informed the ID, and then she gave us permission to go ahead with the opposition on the Section 65.
And when you do that, does she have sight of any of the affidavits that are filed, particularly in opposition?
She does, commissioners, and I must say everything that we were doing, we were sending to the ID. The Section 63 bail amendment application, all the affidavits of the accused were sent to the ID, and our responding affidavit of Mr. Brian Badayashi was sent to the ID, and the defense then asked for a postponement in that Section 63 bail amendment application. They then, on the next date, submitted an affidavit by General Masemola in support of their application, indicating that he had lifted their relocation to other offices. And that affidavit as well was given to the ID. I remember sending an email to the ID asking her that we want to, after receiving this affidavit of General Masemola, we want to respond. Now, how do we do it? Do we subpoena information from General Masemola, or do we serve them with a 28? My question to her was, do we do it by way of a 28 or by way of a letter under your signature being the ID? And she sends me an email to say, serve a 28, which is what we did, and we got further information, which then allowed us to prepare additional affidavits of 2 other officials, which affidavits we then also handed in support of our opposition. So she was kept abreast at all times of what was happening.
And do you recall whether Mr. Parayachi's affidavit in opposition dealt with that specific bail condition related to whether or not you sought that condition to begin with?
What's the question again?
Do you recall whether Mr. Parayachi's affidavit in opposition set out that or indicated that this bail condition was never sought or anything related to that?
You mean the affidavit which was filed
in opposition?
In opposition.
Of the bail appeal.
I cannot recall, but if I check on my emails, maybe those can juggle my mind.
All right, thank you.
Yes.
You can proceed to paragraph 43.
Yes. The bail appeal succeeded while I contended that the magistrate was in law entitled to impose the condition. Okay. While I contended that the magistrate was in law entitled to impose the condition, I was constrained to concede that he had failed to give any reasons for imposing the crime intelligence entry condition. And it was on that basis, that is the failure to furnish reasons, that the condition was set aside as irregular. The review of the magistrate recusal also succeeded, the court holding that the reasons he had given for recusing himself were not in accordance with established principles. At 44, having completed the Section 65 bail appeal and the review, I had no further involvement in the matter. Paragraph reading my concerns regarding the Mokwele matter. Once I was officially involved in the Mokwele matter, Advocate Tlhashwayo and Ramsemi came to me to voice their concerns about the lack of evidence in the Mokwele matter. This is as way back now as 8 August when I became involved. Since there had been no DDPP on the matter before my involvement, I could understand why they felt that they could not address these issues directly with Advocate Johnson due to the power dynamic. Having read the docket on 16 August 2025, I was not satisfied that the corruption charge was sustainable on the available evidence and current formulation of the charge sheet. And as I said, and I said so in writing at the time, my concerns were not the product of hindsight. I recorded them contemporaneously. At the time, 16 August, that Saturday, I produced those queries, and I raised a number of questions. I remember one of my questions to them is, why were these generals arrested? I couldn't understand. Or why are they charged with corruption?
Before we deal with your specific, since there had been no DDPP on this matter before my involvement, I could understand why they felt they could not address these issues directly with Advocate Johnson due to power dynamics. What do you mean by power dynamics?
Yeah. Look, the two colleagues are juniors, and it's not easy for it would not have been easy for them to go straight to the ID to raise issues. I'm talking about issues that they were raising with me. They had a lot of complaints that the investigators were not listening to them. They were not carrying out the instructions that, as they were delivering to them. It appeared to me, in fact, the relationship was not that good between the investigators, especially Brian Parayashi and Advocate Ramsemi. They were not in speaking terms when I came into the team. So I tried to put them together. In some of my emails, I'm saying to them, look, we're playing for the same team. Let's have meetings. Let's talk. Let's iron out whatever problems that we're having. So they couldn't. The two juniors couldn't approach Advocate Johnson, and that is why maybe they felt at ease to come to me and make all those complaints, relate them to me. Not that it was easy for me as well to approach Advocate Johnson. I respect her a lot. I have known her for many years, and I view her as my senior, and therefore I couldn't just barge into her office and say, but what's happening here? Why did you arrest these people? Why this? Why? That is why I put it in an email. I raised all my queries in an email, and I forwarded it to my colleagues. Then I forwarded to her via her PA. And it was not only this one email. You'll see, I think I sent about 2 or 3 where I was saying there's a problem with this case. The way it was investigated, it was rushed. I remember I sent an email directly to her, and I said, it appears this case was rushed. If anything, there might be a case of fraud or there, but the way the investigations were done were just not on with me.
Just before you continue to your specific concerns, when you say that it was difficult to approach Advocate Johnson, was it purely because of her seniority, or was there something in her management style that made it difficult to approach her?
Yeah. Look, I don't want to sound otherwise now, but yes, management style as well as in, she could be unpredictable at times, you know, and you know, she's a very good manager, make no mistake. For as long as she was in the IDEC, that organization, and even now, I mean, we headless as it is for the last week. She resigned last week, Monday, but the organization is continues running itself. It's like a steam train which is on the track. It's all because of the good work that she's put in. You know, the discipline is there amongst the colleagues. So she's done so much work that even when we're not having an acting head or permanent head, the organization can continue to run itself with the help of, obviously, the CEO, Mr. Sissoko, and the three deputies that are there. So I think it was more because of fear that how is she going to react, you know, when we take these issues to her, which was also the same, I mean, for me, at the level of a DDPP. Not that I couldn't raise issues with her, but you don't know how it's going to end. I referred earlier to a meeting where she was angry with me for raising the issue of a Section 27. So she told me straight in front of the two juniors, why are you making an issue about this? Go and work. Why? I've seen the document. Why do you keep on questioning or second-guessing your investigators? So that is what I refer to here.
So in a sense that she, on the one hand, like you said, she's a good manager, but on the other, if you were raising concerns and questioning her decisions, she didn't take kindly.
She didn't take kindly to that, and yes, and she'll tell you straight. You know. So
Were there many instances of this, or was this the only instance? The one instance relating to the Section 27 referral?
To me, Chair, it was only that one instance of the 27. Like I said, I've known Advocate Johnson for many years, and we've had, even though we never worked in the same office, but we've always had a very cordial and good relationship when we met in conferences and so on. And I've known her to be a very good prosecutor, hard worker, and when she came in as a manager at IDEC, the management was, for me, of a very high level.
Thank you.
Yes.
Thank you.
At 46, in my first trial preparation note, I raised, among others, the following questions to the team, but all these are covered in my email. 46.1.
Perhaps, as opposed to reading the summary, we can go to the actual annexure. If we can go to PS3,
Okay.
you'll see it starts with the email,
With the email.
that you sent to Ms. Sekukuni, who is the PA to the ID, where you brought this memo to her attention. And then below that would have been the email you sent to the team members, wherein you gave them Saturday homework while you went and watched a nice game, I see. And then the next page, on page 25, would be where you deal with your concerns. Can we go there?
Yes, Council, you'll see, I agree. You'll see at page 24, it's my email. Actually, the first email will be the last one.
Yes.
You'll see I sent it at 2:51 on the Saturday to the team members, Advocate Tlajwayo, Advocate Ramsemi, Mr. Brian Padayashe, Chief Investigator Daylan Perumal, Investigator Charles Ills, Investigator Patrick Mlambo, and I also copied the project manager, Mr. Sepotale. I reference the subject as trial preparation note 1. Colleagues, here is your Saturday homework. I'm knocking off now to watch Pirates and Sundowns, PS. It was 2:51. I've been in the office since in the morning.
Can I just
Yes.
ask a question? What's the difference between a project owner and a project manager? Because we've encountered Mr. Tlale's name before as a project manager.
Yes. The difference, Commissioner Baloyi, is that Mr. Tlale is one of the 4 project managers that we have. They are involved right from the beginning of the case. They prepare our monthly reports. They are also a link between us and HR in terms of where we need resources, and they also prepare some documents, some 28s when I prepare a memo or an application, and once it's settled, they are the ones that forward same to the office of the ID, and when we receive a report back, they do a lot of work in the team. They help with the preparing for the budget of the team. When we're traveling, they are the ones who prepare memos for traveling, and when we need resources like computers and memory sticks. So they manage the whole project in that sense.
So we're in I think we've encountered Mr. Tlale and we've had a discussion about him where his name appears in a summons, and it says inquiries.
Yes.
My direct question to you is, does he make the decision, I want a summons, and then he prepares the application, or his is an administrative
No,
function?
it's more of an administrative function.
Okay.
Commissioner, he doesn't make that decision lies solely with the DDPP.
Okay.
On what type of investigations on investigation do we go after consulting the team.
Yes.
Whether we go at 2813 or 2818. Project managers do not make those
Thank you.
decisions. Yes.
Thank you.
I'm copying him because he must know what we're busy with, what we're doing. He keeps the file of this matter. So that is why I wanted him also to know that investigations are still outstanding in this matter. And when we're doing a case plan, he must file those. Everything that we do, the project manager must know. So I sent them this email, and the email had an attachment containing queries, and later the very same day at 3:58, I forwarded it to Ms. Innocent Sikukuni. You'll see the message to Ms. Sikukuni has an attachment document 1.docs. The email, the document, that is my document, is now on page 25 with the heading, Dear Team, 1. I have just finished reading the first docket, Brooklyn Cars in bracket, General Kumalo and others. 2, starting from Monday, I want to sit with the prosecutors, Drew and Joy, to start working on refining the charge sheet, to have it ready for the bail condition amendment application on 22 August and for disclosure. 3, as part of our preparation for the case, the response to the application for further particulars in bracket, which I'm sure we are going to be served with in due course, and preparation for the trial, I want to know the following in brackets. The questions are directed to all the team members, I was saying. 3.1, why were the accused charged with corruption? 3.2, who corrupted who? 3, do we have evidence in the docket to prove allegations of corruption against any of the accused? If so, what evidence is that? 3.4, do we agree that in terms of PRECA, the Corruption Act, the giving and or accepting of a gratification should be for a certain aim or objective? PRECA uses the word, in inverted commas, in order to act personally or by influencing another person so to act in a manner described in Roman figures 1 to 4.